Just wanted to say thank you so much for coming today. It's February 19th, 2024, 12 o'clock. My name is Tyler Hoffman. I'm with PA Farmlink. Before we get started, I just want to tell you a little bit about PA Farmlink. So PA Farmlink is a 501c3 nonprofit. We were founded in 1996. We offer four main services. We have farm succession facilitation services. We offer a land linking database for beginning farmers and current landowners. We have a resource hub with a lot of great free resources, links, documents, things like that, which we also include, free education such as our webinars and our workshops like we're doing today. And then we also have consultation and referral services, which includes a great list of ag professionals available in Pennsylvania. We are 97% grant funded. We have 4 staff members and we have a fantastic board. You can see on your screen here, we have a list of the organizations that are represented on our board, and they are absolutely just crucial for the support that we get for this organization, and we're just so grateful for them. Our presentation today is a farm succession webinar called When It Goes Wrong, Learning from Others' Mistakes, a Case Study Analysis. Paul Goeringer is a senior faculty specialist and the extension legal specialist at the University of Maryland. He joined the University of Maryland's Department of Agriculture and Resource Economics in 2012. His research and extension program is focused on agricultural leases, energy leases, landowner liability, production contracts, agricultural nuance issues, environmental law, and estate planning issues impacting agricultural producers in Maryland. Paul has authored over 200 articles and is a sought-after speaker on agricultural law issues. He grew up on his family's wheat and cattle operation in western Oklahoma. Paul graduated from Oklahoma State University with a Bachelor's of Science in Agricultural Economics. After graduating from OSU, he graduated the Juris Doctorate from University of Oklahoma. He is a topic area coordinator in agricultural law for Southern Agriculture Today. He has served on several college and campus committees with his time with UMD. Paul is a past board member of the American Agricultural Law Association, an active member in the Agricultural Law section of Maryland State Bar Association, and a member of the Southern Agricultural Economics Association and the Agricultural and Applied Economics Association. Paul, thank you so much for being here today. We really look forward to learning some of the do's and don'ts of farm succession planning. So
Yeah,
I'm going to stop sharing my screen and I'm going to send it over to Paul, who's going to talk about his case study today.
yeah. So thank you for having me today, Tyler. And go ahead and share my screen. I'm going to go through a quick PowerPoint to kind of walk you through some of this process before we start talking about the actual process. If I do this correctly, you should be able to see my screen, correct? Cool. 4 years into Zoom, I'm getting it down finally. And I can't see everybody's hands, but I'm assuming most of you have started to either think about this process or you've gone through some workshops before thinking about farm succession in some way and how to do this process. And as I point out, I think it's fun to learn from when stuff goes wrong because you learn a lot more from the wrong things that happen in life than the right things, right? If things go right, you don't think about them. The wrong things that happen, you often reflect on and think about how to do them. If you're a normal human being, one would expect you to do that. So this case study and a few of the case studies I use in these workshops around the state of Maryland have come from actual court cases where folks have kind of gotten in disputes over it. I'm going to quickly go through all my funder stuff that I have to go through. None of this is legal advice today. I'm glad we're all good with that. As a part of the University of Maryland and any land grant institution doing extension work, we have to remind you that all our programs are open to anyone. And I'm going to quickly go through the Justice for All slide because we don't need to go through that today because it's being recorded and most of you, if you have questions, can ask them and we can help you have better ability to utilize this program. I do a blog at agris.umd.edu. And as pointed out, I'm a topic area coordinator for the ag law part with a few others at southernagtoday.org. You can sign up for it at southernagtoday.org. It's like FarmDoc, but much more focused on crops in the South, so it may not apply to Pennsylvania as much as other things would. So let's start talking about my PowerPoint and some of the stuff we want to get into today. And I believe you all have a copy of the case study we're going to talk about here in a minute, but I'll show it on the screen as we get to moving forward. So today we're going to talk about, reviewing an estate plan that went to court. None of us want our estate plans to go to court. And we can talk about what went wrong in that process and what the family should have thought about doing better. As I often have to point out to people, and as the next slide will highlight, in your mind, often you are going to create what you believe is a perfect plan, and it is probably a perfect plan in that moment. But as we move through this process and as we go through life, as we're all aware, situations change. We have to be willing to go back, revise, review, and develop new plans that may work better. That's what the case study is going to kind of highlight today. So what goes into developing an estate plan? Most of you have probably thought about this or talked about this at some point. We need to think about if there are minor children involved, who's going to take care of those minor children. We may have specific people we don't want taking care of them. We should probably make that reflective in our estate plans, if that's the plan. Who are the beneficiaries that are going to collect under certain documents that go outside the estate plan, like life insurance, payable on death accounts, land titled with joint rights or survivorship. I cannot remember if Pennsylvania recognizes the other form that is only for married couples, but it would also be joint tenancy with rights of survivorship, healthcare proxies, health business proxies, so people can take care of your business expenses, advanced healthcare directives, so you can talk about what you want done in certain situations ahead of time. The magic document that everybody thinks they need, and we all do in some way need one, a will that will distribute out assets that are under it throughout the process. We'll talk about that here in a minute when we get to the case study. And then we'll talk about trust as well as we go through this. And then potentially life insurance. We often think about life insurance specifically in farm succession planning, mainly because it's a way to sort of equalize out what may be going to one part family member that another family member may not be a part of, such as farmland. If they're taking over the business and another kid may need access to life insurance money just to equalize out those payments. So why do we want to think about all of these things? Well, as we're going to talk about with wills, we get to have the ability to control until our death. We get to direct who gets what. As I point out, as most of us are probably fully aware, everyone we deal with on a daily basis is probably a control enthusiast. We all like to be able to control stuff, especially if it's the property we own. My grandma is no longer with us, and I like to still tell stories about some of the things that happened when my grandpa passed away, and they had half of their property titled in his name and half titled in her name. And I don't mean they had like half the property divided up. I mean, if they owned a tractor, they had it titled where she owned 50% of the tractor. So when he passed away, my mom and her sisters were like, we need to sell some of this farm equipment. No one's ever going to use it again. The property is going to be distributed and rented out. And my grandma looked and said, no, we might need it. So they couldn't sell any of the property. So we literally had tractors that sat around for about 7 or 8 years that couldn't be utilized and nobody was taking care of, because my grandma was a control enthusiast and really wanted to make sure she took full control of everything throughout her life. I tell stories on her, but I did love the woman. She just gives me great fodder for estate planning workshops. You get to select who the executor of the will is, the person who's going to take it to court, work with the attorney to make sure all of that property is distributed according to the terms. You're going to select any guardians that are necessary for those minor children involved. Once the property is distributed, we don't need it anymore. Why don't people like it? You got to go to court. You got to probate it. There's a percentage of the estate that will be taken to pay fees associated with it. People hate that part. They're easily contested, as I point out to people, even if there's a no contest clause, which says if you contest the will and you're party to it and you do that, you don't collect under the will. But there are various reasons courts will still allow you to contest the will. I was going to use a horrible example case study at one point for this, which was recently a North Dakota farmer who, as he aged, became more and more crazy. His children ended up being cut out of the will, and everything went to neighbors. They contested the will, even if there was a no contest clause, because he had diminished capacity. It appears he had dementia as he got older. They may still be able to collect because courts want to be able to know when stuff like that happens. So if things are contested in wills, we may still allow it to happen. It takes time and it's a public process. I never thought about the public process associated with probating a will and how your will's put into the public record and people can actually go see it, until my family had a neighbor who passed away who had a lot of money and no children. And guess what? Everybody in the family and all the neighbors wanted to know who got the money and who got the farmland. So when I went home, my parents not only had one copy of the will in one pickup, they had two copies of the will because my mom needed a copy too to see how it was going as well. Everybody had gone to the courthouse specifically in the area to pick up a copy of that will. So now my dad is 100% concerned that somebody's going to do the same thing to him. So it's trying to walk him through a process that, no, this may not always happen. The other thing to highlight is they're often state specific. If you have property, as many people in this region may do, where you've got farmland in Pennsylvania, Maryland, Pennsylvania, New Jersey, Pennsylvania, and I'm trying to think of all the states that touch Pennsylvania, West Virginia, and alike. We got to have this will set up to be probated in multiple states just to pass that property along, specifically if it's real property. So if it's land, it's got to be state specific. If it's everything else, personal property, that falls under the state where you lived in. So that's a little easier to deal with. But if we're dealing with land, we got to have this thing set up to go through multiple things. The other thing we're going to talk about, and we're going to get into this in the case study, is living trust. So why do people want to go with a living trust? And the idea of the living trust is it continues throughout the course of your life, and you can change it over the course of your life. And once you pass away, becomes irrevocable. We can't change it anymore, and we follow the terms of it. We don't have to go through probate anymore because we have a trust document. We just got to distribute assets according to that trust. None of it's public information. It's very difficult to contest because if you're not in the trust, you're not in the club. You don't get to do anything at that point. You're on the outside looking in. We need not to do anything if we got guardians holding assets for minor children because we already got a trust document to do that. We got to have potential trustee fees. Again, going back to my grandma near the end of her life, she was having issues at multiple various points with her daughters. So she came to me one day and said, "Do you want to be the trustee of my trust after I pass away?" And I said, "No." And I said, "If I do, I want the maximum amount of fees." And she said, "Why is that?" And I said, "Because I'm more scared of my aunts and my mother than I am of you at that point. And I know I'm going to deal with headaches, and I would prefer to get paid to deal with headaches than have to deal with other stuff." She left me alone after that because she knew she was going to have to pay fees and I was going to be too difficult to work with at times. I learned how to make her go away at various points on certain things when it became a problem and my mother did not want me involved. It adds complexity to asset management because now we got to manage these assets through the trust. We still have to coordinate them with other estate planning tools. Oh yeah, and the magic will doesn't go away because at some point we are going to forget to title something under the terms of this trust. And we need a will that basically says, you know, that trust I have, everything I didn't title properly just goes according to whatever the trust document says. We still have to run a will in the background just to make sure we're covered at various points. It will happen. So if you're married, have children, typically we'll see 50% of the estate go to the surviving spouse, the other 50% divided up among the children. What we don't take into account in any of this is your relationship you actually had with any of those people. You may not be talking to your children. Well, if you aren't, you need to write a will because that's the simplest way around this process. The state has a one-size-fits-all solution for all of you if you don't do a will. And the solution is we don't care about your relationship. The other thing that typically comes into play with this that sometimes people don't think about is we may have a couple that's going through divorce. One of them passes away, no will. The court's not going to care about the fact you were going through a divorce was filed. The moment that person passes away, we now have a surviving spouse. And we have intestate laws that say the surviving spouse gets 50%. That may have not been the intent of the deceased spouse. They may have wanted that to go to other family members. Again, if you need to do this, if you're going through and don't want this to happen, do a will. It's the simplest process around it. Finally, the last thing, or not the last thing, but one of the last two things to think about is the estate tax issues that folks always bring up to me. Luckily, as I get to Pennsylvania, I believe you have no estate tax, so you're in good shape. But you still have to think about the federal estate tax, which is 13.61 million. For a couple, that's 27.22 million. If Congress doesn't do anything based on the way it was passed in 2018, if I remember correctly, 2018, 2017, somewhere in there, We revert to permanent law at that point, and permanent law takes us back to whatever the pre-law levels were. I've seen stuff to where they would be about $7 million based on inflation. This goes up each year based on inflation. Portability is an idea that exists in federal estate tax that allows any surviving spouse to use the unused portion of the deceased spouse's federal estate tax exemption. Why is this important? Well, typically we can pass assets on to the surviving spouse tax-free. So there's some ability there to then utilize that unused federal estate tax exemption to pass on more assets to any individual. Typically, as I point out, you have to file the appropriate tax documents with IRS to be able to do this. Accountants have gotten really good at that over the past 15 years. Oh, and then the last thing is you can never, ever, ever get remarried again. Because once you get remarried again, you're no longer a surviving spouse. You're part of a newlywed couple, and you have to hope you outlive the other spouse. Again, it's a vicious cycle you would have to go through to make sure you get this. But you can do it. But the better way to do it is just be the surviving spouse, potentially not get remarried, and you still have this unused estate tax exemption you can use. Gift tax is another way to do this. We'll talk about this with the case study, which is why I wanted to bring it up here. We got about $18,000 you can give to any individual. This goes up each year based on inflation, but it is pegged to the nearest $1,000. So it can only go up when inflation gets it close enough to the next $1,000. For those curious, it has gone up every year for the past 3 years. That's how much inflation has impacted it over the past 3 years. So any of that you go over that counts against that federal estate tax exemption. That federal estate tax exemption is actually known as a unified credit, and it's this unified credit we all have over the course of our lifetimes to use. So we can actually utilize it to draw that down a little bit if we go over that $18,000. And also for a couple, it would be $36,000. There's strategies involved in all this, and we'll talk about it with the case study here in a second. As I pointed out, luckily for you guys, if my Google skills were correct and everything I looked at, you have no estate taxes to take into consideration. So it's only federal issues we need to take about. Let's talk about the last remaining couple of issues, because this is going to come to play in the case study. We have to think about how to handle the farm kid versus the city kid. If we're trying to do this fairly, we got to think about how to handle the kid that stayed on the farm, may have helped the farm grow over time, foregone other things. And how do we treat that kid compared to the kid that may have went off, went to college, gotten a law degree, moved halfway across the country, became a faculty member at a university, and they've had other opportunities to build a career. So how do we do that in comparison to the kid that stays back? There's no perfect answer to this, but as we're going to talk about in the case studies always, and other things too, we always have to remind people, equal is not always equitable. By splitting things up equally, we may actually be disadvantaging the person that stayed on the farm and creating an operation that can't be sustained in some way. So we may actually do more damage doing equal. We have to think about strategies, and good attorneys can work with you on this to do strategies. I use the example, we could set it up in a business entity where ownership resides in the heirs, but the control of the actual farm resides in that person who's staying on the farm, and the participation is with off-farm heirs. So they're just collecting. If there's money that year to be distributed, we can use that. Other things we can look at, business entities. We'll talk about long-term leases because that actually comes up in the case study. They may work in some cases if structured properly, but everything's going to depend on goals. One of the things we always talk about in this process is this is a very goal-specific process. So folks, oh, I forgot, I did not realize you had an inheritance. You're one of the lousy states also that has an inheritance tax with it too. We have that problem as well. That is another fun issue to have to deal with. Tools to use, it's going to depend a lot on your goals. We'll talk about that when we get to the case study. I think that will be a good way for you to think about that. So now I've given us a little bit of time to work through the case study. So my first question is not the first question you actually see. How is their estate plan set up? They got 3 kids. They got an irrevocable trust. And they're going through doing this equally, and that's it. What happens in 04? Or not 04, 97?
Kathleen and her husband came back to help with the farm.
Yeah. And then what happened in 08 or 04? Not 08, 04. I think somebody died in 08. Did they transition to organic in 08 or 04? I'm going to keep saying 08 because now it's in my head.
Yeah, they did.
Yeah. So along this process, what should they have done?
They should have sat down and revised it when Kathleen and her husband came back, and then when I believe he was Henry died.
Mhm. Yep. Yeah. So they have a plan to start with, don't they? At
They
that
do.
At that point in, whenever they develop it, I can't remember dates for the life of me. In 95, when they developed this estate plan, they have a plan. They don't have anybody back on the farm, right?
Correct.
In 95, it makes sense to divide the farmland up equally, doesn't it? Because nobody's going to come back to the farm. So this way, at least everybody's getting a piece of ground. Now, there are certain things we don't know about this piece of ground. Again, I like to use my grandma a lot as a good example for what not to do in the estate planning process. What might change the value of this farmland that I don't have in the fact pattern? What if there are homes on one of these pieces of property? Does that change the valuation of this property in any way? And what they're doing with it? It potentially does, to where we have to think about how do we deal with a home and all of this too. That's not clear from what all I ended up dealing with. Again, I took a court opinion and turned a court opinion into a fact pattern, and court opinions are often lacking in a lot of detail that we need. But if there's a home involved in all of this, this is going to change some of that. So it may not have been as equal, but we got 3 parcels of land. So when they set this up, it's perfect. At that moment, remember I always say your plan is perfect in the moment. It changes over time. In 97 or 04, when we have Kathleen and her husband come back to start running the dairy, in 04, when they start transitioning to dairy, what do we have in 97 and 04? Do we have what are known as major life events? Is your child moving home to take over the family operation a major life event?
Yes.
Yeah.
Yes, definitely.
Yeah, it's a major life event. So now at this point, we really do have to start thinking about how to change that plan. Because even when we move to organic, that's a big cost for an operation, isn't it? We're transitioning into a new production system. It's potentially something we need to start thinking about at that point. So now we have this new goal of, we got Kathleen and her husband taking over the dairy, buying the herd, managing that herd, transitioning it towards organic over that period of time. And they put a lot of costs in there. So that leads into set question 3. What protections do they currently have based off the limited amount of facts I've given you to protect themselves?
None.
The only thing that they have in there, that if the farmland is sold to another person, then Kathleen and her husband could remove the capital improvements or be appropriately compensated, and that the rent payments would be applied against the purchase price. But I'm not really sure if that would be a good protection for them or not.
And normally when I talk about this question, I say they have a hope and a prayer. They have a hope that everything will work out and they can do this. My question often is, and I don't know who Kathleen is, and I changed their names and all of this, so I can't even remember what Kathleen's real name is a few years later. Kathleen is building a business on the assumption, basically, that her parents will always be there controlling the property, if you think about it. Because while mom and dad are alive, she has the most protections humanly possible. It's once they pass away that we have to start figuring out what other people are going to do within that system to figure out what they're doing. So in this, they really have moved forward with a business made major changes to it, just what feels like at times that, mom and dad will always be there, we'll always have this land. And as often pointed out to me when I use this case study and stuff, are you entitled to land at any point in your life? You're not entitled to anything really. So it's not really that they're feeling entitled. They're thinking their mindset is wrong potentially to be able to protect themselves. My other favorite question, because this comes up a lot, what's sweat equity for those that have done sweat equity in their life on a farming operation? It's where we do work and we're told all this will be ours one day. I love using GIFs in presentations, if you did not know, because mainly it takes your mind off the dullness of the legal stuff I'm teaching you about, and hopefully you remember something. Normally, if I do this as a longer presentation, I utilize one GIF from Monty Python and the Search for the Holy Grail, because it's the only GIF in my entire presentation that matches what you're about to do. And that is the scene when the king or the Lord is up with his son in the deal and looks out at the window and goes, "Lad, all this one day will be yours." In England, that worked because it was a system to where we knew who was going to inherit. In the US, our system is different. We built it upon no hereditary inheritance based around what your title was or anything like that. So in this, if we're telling you it's going to be yours someday, we actually do have to physically do something, put that into paperwork, get that done. We often have to talk to people that, in this case, where they are really putting in a lot of sweat equity within this operation, they have no real protections to get back anything. They might get their capital improvements back and be able to sell those, but without a dairy attached to them, that's going to be a problem potentially. They may not be as valuable that way. So they're losing out on a lot, and they're not going to be able to capture that sweat equity. In this case, they really should have been compensated a little bit more, maybe been paid differently to do this. I don't know how they were paid, so I'm just making assumptions here. There really is nothing to protect that sweat equity. And I think we've heard from a couple of people, is there anything you would have thought about doing differently in this situation? Would you have revised your plan at some point? If you learn nothing from today, a lot of this is about at some point we're going to have to go back and revise these plans. This plan was perfect the day Henry and Alice wrote it. It sucked 2 years later. It no longer did anything. Goals changed at that point. We got to rework this thing and we got to revise it. We'll go through the rest of it in a second. We can talk about what happens in a second, but I work a lot. The same attorney that sent me the Reddit story about the head on the mantle also is in his farm succession and any business succession stuff he does in Iowa. He sets people, everybody that's involved in the farm succession planning process, down in the conference room at the end once they get the plan developed, and he just starts killing people in the room. He figures out what everybody's job is and goes, okay, they're dead. Who fills that role now? What do we do in that situation? That really is to help you start thinking about, if we start losing key people, how do we change this plan to make it work better? In this case, we got Henry and Alice. If Henry and Alice go away, how do we maintain that Kathleen and her husband can at least keep a dairy going? I have no real answers for how that's going to happen. It's going to have to be different than what they did. So I'll let you go back and finish with the last page and a half. We can talk about that. I'll give you about 3 or 4 minutes to read it. So now that we have Alice, who's passed away, what happened?
Everything's a big mess. Nobody's going to talk to anybody when the final outcome. Kathleen and her family are probably going to uh lose their business because I don't think they have $558,333 to give to the other two uh brother and sister and their families, and everybody's gonna hate each other for the rest of their lives. And it's a big mess.
That's how family grudges start, right?
Yes.
This 3 generations from now, we just know we don't talk to that side of the family and no one remembers why or the wrong that happened or what happened. We've now probably potentially witnessed a family grudge be developed that create problems. Yeah, that leads to, yeah, you've succinctly said everything that is happening within this. I will point out, this is in Wisconsin, and I need to get the chat box up so I can see questions. Yep, and I'll agree with that point that was made, that the values can often change because of oil, solar, anything else going on this property would change some of that going into it as well. So we see now that they passed away. This was actually in Wisconsin, and the way the law was set up in Wisconsin is about the fairest I've ever seen within the process, because in most states, because we have everybody more or less entitled to a third, we can force a sale at any point. One person can force a sale to make this situation work. So we've already set Kathleen and her husband up from earlier for failure in all of this. Our goal should not be to set people up for failure ever. It should be to probably potentially make them succeed and figure out ways to make them succeed while taking care of the other children at the same point. Art, remind me at the end, I will explain if for those that are parents in the estate planning process, what your number one goal is as we move forward on this. But in this, the son is the one, Charlie is the one that actually instigates most of this. What's he seeing in all of this? He's not working on this business. What is this to him at this
The
point?
dollar sign.
Yeah, it's money at this point, potentially. So he sees he can get about, $500,000. That may be a good bit of retirement income or something for him to look at as well. So he's not thinking about his sister potentially at that point. He's wanting his value out of that operation. And probably if Kathleen can pay him, he'll be more than happy within this. And yes, so what happens if they want to press for the sale to the highest bidder? They can. As the people that are collecting under the trust, they are fully entitled to that. And that's what started this process in place to do this. For those curious, the district court actually ruled against Kathleen and her husband to start with. And then before the state Supreme Court said, actually went back and looked at what the referees recommended and how to divide the property up. And because they would be substantially impacted, they had to work out a solution that allowed them to stay on the property and figure out a way to pay it off over time. It was the most fairest solution I've ever seen, because in most of these, the courts will look at it and go, our hands are tied. We can either force a sale or nothing, and they have to force a sale potentially. So this was slightly a more fair situation than what I've seen in the past with this. And I think we've kind of talked about the outcomes with everybody. Like, what's the outcome do you think is going to happen? This is how family grudges develop. No one's going to talk, as Weta pointed out earlier. And I thought that was Weta by her voice, but I might be wrong. So nobody's going to talk. Everybody's going to be mad. The only two that potentially may talk are Kathleen and Rosemary, because Rosemary wasn't throwing up a fight and she actually wanted to work with her sister. Nobody in the family is probably ever going to talk to Charlie again. But let's be honest. If he's doing this, do you think anybody really wanted to deal with Charlie from the start? He probably was the problem child to start with. And this is where I get to the point for those with children in the room. Often in estate planning, as I point out in workshops, your goal in doing this process is to figure out which one of your children is going to cause a problem. And the estate plan should work to provide ways to contain that problem, because the other heirs should not have to deal with the one problem that's going to come into play at times. It may not always be possible to do this. but it's one thing to think about. The other thing to point out, and it was already brought up too, how likely is it they're gonna have basically $1.1 million floating around in a dairy operation to pay this debt?
They're not.
How likely is Farm Credit to extend a line of credit to buy this property at $1.1 million?
Are they going to be able to pay for it? And I mean, how close are Kathleen and her husband to retirement? Is somebody going to be able to take it over? I mean, there's a lot of ifs there.
Good questions. We don't know the answers to any of those because I did not include them. But if they're close to retirement, it may be something they can't do. If there's no potential heir, there's probably going to be problems. And as one of my counterparts that teaches on this same subject often points out to people, does it make sense for a business to buy the same asset twice? Have you effectively bought the same farmland for the business twice? In what business does that make sense? It makes sense in no business. If we're expanding the operation, it makes sense to buy a new asset. This is just to keep the asset base. This is really a problem. This is a problem that could potentially been dealt with much earlier in this process, as I keep highlighting. Where do we need to go? We do keep buying it. I'm now paying attention to the chat. But yeah, so this is potentially a problem. Where could we have solved this problem early on? From the start, when Kathleen and her husband moved back. If we had just done some basic stuff early on in this process, would we have ended up in this situation?
No.
No. So what could we have done differently? If you were if you were Henry and Alice, let's go back to the cause of the problem. As I always point out, Henry and Alice don't realize they did it, but they set Kathleen up for failure from the very start.
The first thing they probably should have done was to bring everybody together and say, we need to do something, and listen to the three children before they wrote the original plan.
Yeah. So we needed to start off. That's a good point. We need to start with a family meeting. At that point, when Kathleen and her husband moved back, start with a family meeting. Okay, we're dividing the assets up this way. We now have people moving back to the farm. How do we handle this situation? Let's start talking about how do we do this fairly. Let's start talking about, okay, here are things that are going to come into play. Kathleen and her husband are wanting to seek to continue the operation. They're going to need the land base to be able to do this. What are things we can do to, treat them fairly and treat the other two children fairly? We don't know what those answers are. As I often point out to people from doing this over time, it can be as simple as they just want to be a part of the business is all they want. They may not want a lot of stuff because they may be smart enough to realize or reflect it. I guess it's not smart. It's more reflective and aware to be able to look back and go, oh, we got all this other stuff. They didn't get this stuff over here. So this is slightly fair in the long run. We both got different things at different times. To do that, we can start thinking about, especially if we're working with, people that are experts in this, to think about how to handle this situation in a way to where, yeah, we may have a few assets over here, but there may be other things we can do to potentially make the situation more fairly, either doing some investment strategies to grow some money potentially over time. Again, the same counterpart has a model that basically shows if you start investing money early on when you have children to potentially create a pot of money over here to the side, we might be able to settle some of these disputes easier, but it's things people don't think about. Henry and Alice are too old at that point to do that. So there may be other things. If conservation easements are available, that may be something we can think about. How do we preserve the farmland in a way, bring in money to help take care of other things that will potentially come out, life insurance, but that may be too costly later in life. Other things we can do. The biggest thing within all of this that they probably should have thought about doing is start this process very early in life when they had children. So then they could have started investing and doing some of the simple management stuff that would have allowed this to continue on. We all think about doing this much later in life. And I didn't throw the stats up. Does anybody know the stats of like what the average, for the American population who has an estate plan? It's less than 50%. So as I always point out to everybody in the room that doesn't have an estate plan, for once in your life, you're in the majority. Be happy with that. But also, as we age, we start thinking about it because we're thinking about death at that point, and we're contemplating what could happen to us. It's also a process when we're younger, we should start thinking about doing, because we can set people up better for success and potentially manage these deals. And if you got nobody that wants to farm in the end, what do you have? You got a pot of money over here and a pot of land over here. You can combine them together and divide assets up. It works a lot better. Oh, that's all my pontificating on the case study.
Well, it looks like we're gonna wrap it up here. I'm gonna cut you short here, Paul. If anyone does have any questions for Paul, you can always send him or myself an email and I can make sure it gets to him. And Paul, thank you again. It was so great hearing your conversations today. All right, everyone. I hope you have a great day.